Hey guys, so today I just wanted to go over a few vocabulary terms. I know that when we as attorneys speak, it is Greek to you, and it can be very frustrating when you hear attorneys or judges saying acronyms or saying words that you have no idea what they mean. So I'm not going to talk to you today about the rules about these words, but I am just going to give you some general definitions of what they are. The first one is the petition. The petition is the document that you file when you start your case. So you may use it to start your divorce case or a petition to start your parentage case. The response is the document that is due by the other party. So once you file your petition, you serve it on the other party. The other party has to file a response. Then there is a POS, or proof of service. And this document is the declaration of the person who sent documents to the other side or to other people. So you are proving that you served documents on the other side. So as a party, you are generally not allowed to be the one to serve documents on the other side or other parties. So somebody else has to do it for you, and they then fill out the proof of service, and then you file that with the court. PDDs. PDDs are preliminary declarations of disclosure. So these are mandatory documents that have to be filed in your case, in your divorce case. There are no PDDs in a parentage case. So in a divorce case, these are your financial records, property records, income, expenses, assets. There are a few different documents that go along with your PDDs. But what a PDD is a preliminary declaration of disclosure. So now we're moving into the part of the process where you can either obtain temporary orders or you can modify a judgment. And to do that, you go through the process of a request for order. You're asking the judge to make new orders. That is often referred to as an RFO. So you'll hear people say, oh, she filed her RFO on this date, or your RFO hearing is coming up. That is your request for order. And attached to an RFO is your declaration. And this is a document that you sign under penalty of perjury, explaining to the court the facts of the case and explaining to them what you're requesting. So a declaration gets attached to your RFO, and there are other times in a case where you will file a declaration without attaching it to an RFO, or maybe a declaration of a third party. Once you serve an RFO, or if you have received an RFO, then you do a responsive declaration. Some people call it a responsive dec. It's a responsive declaration. That is your reply to somebody's request for order. And again, you're going to attach your declaration to that document. Now, if you're asking for support, or if this is a divorce case and there's property and so forth, then you're going to do an I&E. That is an income and expense declaration. So we refer to that in the short by I&E. If you're not able to settle your case early on in the process, you'll find yourself at a status conference. A status conference is an opportunity for you or your lawyer to explain to the judge where you are in the process. Do you guys need more time to gather more documents and evidence? Are you ready to proceed to trial? Would a settlement meeting help? This is a conference on the status of your case. So, status conference. Usually, if the case is looking like it's heading toward trial, they will set an MSC. And an MSC is a mandatory settlement conference. This is an opportunity for you and or your lawyer to talk with a judge. Sometimes it's your own judge, sometimes they assign you to a different judge. But you have an opportunity to talk with a judge and see what their perspective is. It doesn't mean that they are going to prejudge your case, but they may give you some thoughts on your evidence, or they may give you some ideas on how you can come to a compromise to try to avoid trial. And if you're absolutely going to trial, then they may just help you figure out what documents or put you on a discovery path with some deadlines and so forth. So what you need to know about an MSC is it is a settlement conference. The judge does not have the authority at that conference to make orders. So this is not an opportunity for you to ask the judge to make an order or make a finding. It's an opportunity to work on settlement. After that, if you're really headed to trial, then you're going to get a TRC date. A TRC date is a trial readiness conference. And this is an opportunity for you to tell the judge, yep, we're ready to go. And actually, before that, one step before that is your TSC, and that's your trial setting conference. And that's where they will give you your trial date. And then you're going to have a TRC prior to the trial date where the judge says, are you ready? Are you really ready? And then we'll confirm your trial date. There's a couple kinds of trial. You have a short cause trial or a long cause trial. Short cause trials are generally under 2 hours, and those are easier to get because they're shorter in time. A long cause trial is over 2 hours, and so short cause or long cause just refers to the length of time that you or the attorneys anticipate it will take to do the trial. So I hope this little vocabulary primer has been helpful. If so, please feel free to leave a comment, leave a like, share, and I hope to see you soon. Feel free to reach out if you have any questions, post them in the comments, or feel free to set up a time for us to talk at my Calendly link. Take care. Have a great day.